Please be seated. Welcome to Division 2 of the Colorado Court of Appeals. I'm Judge John Daly. To my right is, I was going to say Robert Furman, but David Furman. And to my left is Judge Leno Lipinski, Bjorloff. And we're here today to hear just one argument, and it's People versus Hookfin. Counsel are both present at the council table. I take it you're prepared to go?
Yes, Your Honor.
Okay. Did you have a chance to read the oral argument instructions when you came in? Okay.
Yes, Your Honor.
Thank you. You don't need to do that anymore, but thank you. Do you have any questions about them? No? Okay. Remember, when you come to the podium, give us your name and registration number. Remember, confidential or sensitive information should not be mentioned because we are live streaming our arguments. We're also archiving them on the state website. And for those in the audience, please turn off your cell phones and pagers so as not to disrupt the oral arguments. Also, I don't believe there's any sexual assault victims or anything like that in this case, but just in case there are sensitive information, let's not mention it. Any questions? Okay, I think we begin.
May it please the court, my name is Meredith Osborne, attorney registration number 50469. Today I would like to discuss the first three issues in this case, but I recognize that with our limited time, the court might have some specific questions, so please feel free to interrupt and redirect as necessary. I'd like to begin with issue number 2, which is the sufficiency of the theft conviction. And this argument is essentially very simple. There was insufficient evidence to support the jury's finding that Mr. Hookfin took on a single occasion more than $1,000. This conclusion is supported by 4 different undisputed aspects of this case. First, the complaint charged Mr. Hookfin under subsection 1A of the theft statute. Second, the complaint listed only the elements of subsection 1A of the theft statute. Third, the jury instructions followed only subsection 1A of the theft statute.
May I ask, did the complaint also list subsection 4?
No.
Okay.
Not only did it not list subsection 4 generally or specifically subsection 4B, it didn't include the elements of subsection 4 in any respect. Finally, the verdict forms and the interrogatories therein followed subsection 1A of the theft statute. As this court recently held in Ramos, these are different crimes. Subsection 1A involves thefts that are single takings from a single entity or person. Subsection 4 is very unique to the theft statute, and that allows the prosecution an enormous power to aggregate multiple thefts either within a period of 6 months from different people or over any period of time from the same person pursuant to a scheme or course of conduct.
Are they different offenses or are they separate units of prosecution?
Well, in Ramos, this court said they are separate offenses.
They did? They said it that directly?
Yes, it said the plain language indicates that under subsection 4A, this is a separate offense, and that was the holding of that case. The case involved a slightly different appellate issue because in that case, the defendant had been charged under subsection 4, and what happened is the defense tendered at the end of trial an interrogatory that said, if the jury finds that only one theft was committed, i.e. it does not find all of the thefts alleged in this case, you must find not guilty under subsection 4. The trial court had rejected it, and this court last year, or 2 years ago, said, these are separate crimes. You have to vacate the subsection 4 conviction and enter on the one finding by the jury. So in this case, yes, it's slightly different, but those holdings are extremely relevant here because had the prosecution wanted a subsection 4B conviction in this case, and I quote, it was a condition precedent to charging subsection 4. That's what Ramos said, because they're separate crimes. And Ramos is not out on a limb on this issue. Ramos relied on the dicta in Simon, which is a Supreme Court case. And in Simon, it was a pattern SAOC question whether the pattern was a sentence enhancer or a separate crime. And the Supreme Court intervened and said, unlike the different aspects of the consolidated theft statute, what you have here is a pattern sentence enhancer. And it explicitly distinguished the theft crimes, which are, subsection 1 sort of crimes and then subsection 4 sort of crimes. So in this case, all this is relevant because the prosecution charged him with a single isolated theft, and the evidence at trial didn't support the jury's finding on that single isolated theft of $1,000 or more.
Did the prosecution charge under the continuing offense part of subsection 4?
No. No, there's nothing in this case other than the prosecution's argument in closing, which is just argument that deals with aggregation. And my theory of the case is either everyone was just mistaken and operating under a false understanding of the complaint, or it was because the prosecution made a deliberate choice to charge under 1A, present multiple thefts, and try and get a single conviction. And I tend to think that the latter is what happened. But in any event, no matter what happened in this case at trial, there was just insufficient evidence to support the $1,000 or more based on the prosecution's evidence. Finally, I'd just like to briefly respond to two arguments by the Attorney General. First is that we essentially agree this is not a constructive amendment or variance issue. The state wants to recast this as a constructive amendment or variance issue. That's not what this is, because the complaint and the jury instruction and the interrogatories on the verdict forms were all consistent. There was no difference in the jury instructions and what happened in the complaint. Likewise, with the variance issue, there was no variance between material evidence alleged and then proven at trial. What simply happened here is that the allegations in the charging document simply weren't proven at trial, and that's different than the variance issue. So if the court has no further questions on the theft issue, we can move to number 1, which is merger. Okay. So with respect to the merger, the state and I are in total agreement that theft is a lesser included offense of computer crime. This court is not bound to adopt that position, that concession by the state, and so I briefly would like to just go over the reasons why this is a merger, or a lesser included offense, I'm sorry. First, the plain language to commit is a transitive verb. It means a completed action. That's just the plain language of what we have here. It is relevant in other subsections of the statute what it does not say in subsection 1D. In subsection 1B and 1F, for example, it says they commit a computer crime with the intent to do something else, or they commit a computer crime with for the purpose of committing theft. And those suggest that it's not necessarily a completed action. So that language is missing in subsection 1D, and I think that that's very important.
Counsel, did the Attorney General's office concede that point?
It was my reading of the answer brief that we are in complete agreement, and in fact, that is part of their argument on issue number 3. They rely on that concession for arguing that the computer crime, the reason that in issue number 3, we are allowed to aggregate under the computer crime statute is because theft is a lesser included offense. So that's my understanding. So yes, I do think we're in total agreement.
And is that your understanding too?
Yeah.
That under computer crime you can aggregate the
Oh,
theft?
absolutely not. No, that is not. I don't agree with that.
Well, let me ask you this. So well, actually, your position was the theft in this case was not the aggregated crime anyway.
Correct.
Thank you.
Yes, and I want to be really clear about the relief we're asking for. So I don't have the minimus in this case to once again show what crime was charged in this case, because Mr. Hookfin received a economic crimes probation. That probation and what he has to do in terms of restitution in this case does not go away, even if this court agrees with the errors that I'm alleging here. He's going to continue to have to pay restitution on this money, and I think that that's really significant because that's what the prosecution really wanted out of this case at trial, and that remains regardless of what happened.
I'm sorry to interrupt. So let me clarify. Let's say we agree with your first argument that there's not sufficient evidence of theft. What's the remedy?
Well, if I could just take one step back, if this court agrees with merger, it doesn't even need to consider the sufficiency of the theft or the Stella Bot issue, in my opinion. If the offenses merge, we are simply left with whether or not computer crime allows for aggregation, and it clearly does not.
So let me follow up go ahead.
No, I'm sorry.
So let me just follow up. I'm reading from page 10 of the answer brief, and if you could address this. The AG says, given the overall statutory framework, a Class 4 felony theft involving a computer would be a Class 4 felony computer crime, and a Class 1 misdemeanor theft involving a computer would lead to conviction for Class 1 misdemeanor computer crime. Thus, were theft convictions intended to merge into computer crime convictions, subsection 1D of the computer crime statute would be superfluous.
Yeah, so what merger actually considers under Reina Abarca and the statute is the strict elements. It doesn't consider how the penalties might impact the merger analysis. And so what we're left here with these strict elements under Reina Abarca and the statute are a crime that is defined as using a computer to commit theft. I think this is one of the clearest examples of merger that I can think of. I disagree with the Attorney General's point that how the penalties operate and might create, well, I don't think that they render anything superfluous, but I do see that there might be a problem with the penalties. And I think that's an argument for the legislature, not this court.
How, counsel, can you argue that theft merges into computer crime, but computer crime does not incorporate the crime of theft if it involved an aggregated amount?
Okay, that is a different argument than what we have in this case. So I completely agree that had the prosecution charged an aggregated theft crime in this case, I would not have a merger issue. And that's because the lesser offense would have an element excising it from the ambit of the greater offense, and that doesn't exist here.
Because your position is it does not incorporate theft as understood by 184401 into the computer crime statute.
So maybe I'm not understanding exactly what Your Honor is asking, but
You're pretty close.
I don't think that the computer crime statute incorporates the consolidated theft statute. That I don't agree with. I do agree that theft is a lesser included offense, and I think the Attorney General's argument about whether or not the computer crime statute encompasses the entire theft statute as well, I don't know if it ultimately matters in this case because the prosecution never charged 4B, the end. And also, it's not just what they decided to charge. It's what they proved. It's what the jury was instructed on. It's what the verdict forms reflect. So even if that were true, I still see that there's a sufficiency problem in this case under both counts.
What would be the appropriate penalty if we do find a merger between the two convictions? Where does that leave us?
I think that leaves us with a Class 1 misdemeanor computer crime conviction where Mr. Hookfin continues his probation and continues to pay restitution in this case. If the court has no further questions about these issues, I would like to reserve the remainder of my time for rebuttal.
Good afternoon, Your Honors. May it please the court. My name is Patrick Withers, bar number 45380, and I'm here to represent the people of the state of Colorado in this matter. If I may, because it touches on multiple issues in this appeal, I would like to begin by discussing the definition of computer crime under subsection 1D before drilling down into the particular issues. I agree with the defense, actually, on this point. Subsection 1D criminalizes thefts involving a computer. We know this from the plain language, and we know this from the model jury instructions. As defendant rightly points out, the jury must be instructed on the elements of theft even if no theft was charged. This definition has implications for both defendants' issue 1 and issue 3. As to issue 1, while I do not concede merger, I do agree with defendant that theft is a subset of computer crime, as the jury has to consider the elements of one when considering the other. But because theft is a subset of computer crime, and because the jury must know the law of one to understand the other, you cannot divorce the theft and computer crime statutes as defendant seeks to do in issue 3. So where does this leave us? In this case, one theft was found by the jury, and because that theft involved accessing a computer, we had one computer crime conviction.
how many times did Mr. Hookfin access a computer under the language of the computer crime statute?
Under the language of the computer crime statute, was at least a few dozen times. The evidence was undisputed. I'm sorry, Your Honor, I don't have the exact number, but the evidence was undisputed that every time that he applied for benefits, it involved using, I believe every time was using a phone, but it was either using a phone or using a computer.
But he
of
was
some sort.
charged with only one act of accessing, is that correct?
He was charged with one count, yes.
So that would assume that he only only accessed the computer once. So if you could help me understand how he was charged with only one act of accessing.
So Your Honor, it's the people's position, and I believe we share the same understanding as with the defendant, that, again, this crime is theft, accessing a computer. And here, there was one theft. That theft was the aggregate, was that aggregated amount. And so because, I'm sorry, Your Honor.
No, I was just
Okay.
going to ask, did the jury receive instructions on the aggregated amount? Did they receive instructions on the continuous amount? Did they receive instructions on any of that?
No, Your Honor, they didn't.
Then how is it as a matter of law just one theft?
Well, as a matter of law, it was one theft, Your Honor, because it's the people's position that Ramos is incorrect. Under Ramos, I would agree it was error, because theft and aggregated theft are two separate crimes. But it's the people's position that there's one crime of theft, and there's no need to instruct on anything more than was instructed, that between this date range, this amount was taken. And what I base that on, Your Honor, is discussed in the briefs. The Lewis case from the 80s talks about this. It was a different instructional issue. It was a unanimity issue. But in Lewis, they said, and granted this was the earlier version of the theft statute than 2009, in Lewis, the court said the jury doesn't need to agree on the particular acts of theft in what I'll just call an aggregated count. All that's needed is that the jury must find that a theft occurred and the value was of a certain amount. Of that.
Mr. Withers, sorry to interrupt.
Yes, Your
So 184401-4A requires more than one, or allows more than one, correct?
It allows them to aggregate as a unit of prosecution, is the people's position.
Okay, and the jury was not instructed on anything under 4A?
No, Your Honor, it was not. I'm assuming, Your Honor, you
So is
mean...
that problematic, or?
I don't believe so, Your Honor, because again, the jury was instructed that it had to find a dollar amount within a certain, had to find the range of the dollar amount, and it had to find the other elements of theft. And especially here, there was no, this case came down to intent. It was whether Mr. Hookfin believed that he was authorized to act as he did, and that there was no intent to commit a theft.
Yeah, go ahead, I'm sorry.
It's my understanding that there was no real dispute that he received the amounts. There was no real dispute over the amounts themselves. It was purely an intent case, Your Honor.
Counsel, if this were not an aggregated amount, would there, you be accessing the computer each time for a certain amount?
I'm sorry, Your Honor. I don't
Yeah,
understand
well,
the
let's
question.
go back to the original theft statute. If you did not aggregate these things, would they be individual thefts?
Yes, Your Honor. If they are not aggregated, and under Ramos, I believe, if this court enters on the lesser includeds, which Ramos discusses, then yes, they're separate thefts, and if they're separate thefts, there has to be one computer crime conviction for each theft. It's the people's position that there's a 1-to-1 ratio, Your Honor. Because computer crime is simply theft committing using a computer, if there's one theft conviction, there's one computer crime conviction. And so if, under the hypothetical, if defendant had been convicted of 5 theft offenses and there were 5 theft convictions, then I would agree with defendant that it would be improper to aggregate those various thefts into one computer crime conviction. But again, that didn't happen here. There was one theft conviction, one computer crime conviction. And so as to issue 3, whether there's whether there's an aggregation provision in the theft statute itself, it's really not at issue here.
So you don't think the jury has to be instructed on aggregation or continuing offense to basically glop all these thefts or all this computer crime together?
Well, again, as to the theft, no, it's my position that they don't. They have to be instructed simply the amount, the dollar ranges, the elements of theft, and the dates. And that's what was charged here. And as to the computer crime, again, there's nothing really to instruct the jury on with computer crime because the jury found that a theft occurred and that it involved a computer. I think it would be a much more difficult issue, Your Honor, had there been, in my hypothetical, 5 various theft counts, 1 computer crime count. Then there would need to be something that explained to the jury which theft count was, for lack of a better term, underlying the computer crime.
So help me understand this. Mr. Hookfin accessed the computer multiple times, but he was only charged with 1 act of accessing. It seems to me there's an inconsistency in aggregating the total amount that he allegedly wrongfully took if he was only charged with reaching out, contacting, accessing the computer system once. Don't we need to look at exclusively how much he obtained through a single act of accessing the computer?
Well, Your Honor, with respect, that's not how I read the statute. How I read the statute is you not just access the computer, but you access to commit a theft, which is how the statute reads. And so simply accessing the computer, we're not counting the number of times he accessed a computer, we're counting the number of times he accessed a computer in the commission of a theft.
And that still is multiple times. So the prosecution's theory is, it strikes me that there was a separate act of accessing, in other words, a separate violation of the computer crime statute each and every time he called in, which strikes me as being, as involving multiple counts.
Well, Your Honor, I understand what you're saying, but again, there's only 1 theft here. And it would be different if there were, I could see a problem like Your Honor is signifying, for instance, if there were an aggregated theft count where some of them involved using a computer and for somehow it also involved, I don't know, breaking into the department, for instance, where some of them involved a computer, some of them didn't. Then I would understand. But here, every single count, it was undisputed that every single count every single specific act involved a computer. And because of the way that the prosecution charged this, there was only 1 theft. And this is part of the, admittedly strange way that the legislature has defined theft. But I would urge this court to not look at it as multiple thefts aggregated. It's multiple acts aggregated into 1 theft. Because under Colorado law, yes, it happened on different days, but as the legislature, at least as I understand it, and again, Ramos disagrees with me, but as I understand it, how the legislature has defined this as a unit of prosecution is 1 theft.
If we find a merger of the convictions, what would the appropriate penalty be?
For the computer, I guess there's only 1, Your Honor.
Right, at that point. I'm assuming, for argument's sake, that we find that there was
Correct.
a merger.
Well, again, I think that in some ways all roads lead back to Ramos because, again, under my reading, this court would need to determine if there was 1 theft or 20, 30, 40, because as I read Ramos, the proper remedy is even if there's 1 computer crime conviction, you would have to determine if there's still 1 theft. Because again, it's theft involving a computer. And so under Ramos, this court would have to determine if that 1 theft, even if it's merged, whether that underlying theft is 1 or many. Because my understanding is if the defense is correct and if this court follows Ramos, the proper remedy is saying, no, there was not 1 theft. There was actually the lesser includeds of all the specific acts of theft that must be entered. That was the remedy in Ramos. Ramos, there was only 1 act found, and so it ended up being a MIT change, if nothing else. But my understanding of Ramos is you would have to look at how many thefts occurred, and my argument would be is the computer crime would also have to be broken up. Granted, that's not what the people seek in this case. I want to make that clear because that could lead to many more convictions than the defendant actually was convicted of at trial. That's not what the people seek, but I think under Ramos and just the logical implications of it, I think that's what would logically follow.
Remind me, counsel, does subsection 4 of the theft statute require that the defendant be charged in any certain particular way? Does it actually talk about, you have to aggregate them in the charge, you have to notify in a charge, the same thing for continuing offense in the charge itself?
No.
For theft?
So let me read it out loud, because that ties right into what I was just going to ask. 4A, when a person commits theft twice or more within a period of 6 months, 2 or more of the thefts may be aggregated and charged in a single count, in which event the thefts so aggravated and charged shall constitute a single offense.
Yes, Your Honor.
And the theft in this case was not charged in that manner, was it?
I'm sorry, Your Honor.
Was the theft in this case, theft was also charged in this case, right?
Yes, Your Honor.
Yeah, class 4. Was it charged as multiple acts under subsection 4?
I believe it was charged as a date range and an amount. I don't believe it quoted that language, Your Honor, no.
But it was charged under subsection 1, correct?
Yes, it reflected subsection 1, correct. It's the people's position. And again, if Ramos is correct and these are separate offenses, I agree that that was improper. I mean, I would say it's a variance issue, but regardless of whether it's variance or a sufficiency issue, if Ramos is correct, then defendant was charged improperly. It's my position that Ramos is not correct, that this is one offense, and you don't need to specify subsection 1 and subsection 4 because it's a unit of prosecution, and there the issue becomes, was defendant on notice enough of the charges? And I think when you look at it like that, then there's really no issue because, again, this was an intent case and nobody was really, there's multiple statements in opening and closing. Nobody was really fighting about the amounts or the circumstances beyond it. Again, this whole case came down to, did defendant believe that he was improperly taking these dollar amounts, or did defendant believe that he was authorized by the department? That was what the case was about. Unless there are any other questions, and given my time, I ask this court to affirm. Thank you very much.
Just very briefly, I'd like to talk about the Roberts issue in the 2009 amendments and how they do and do not bear upon this case. So what happened in Roberts is the Supreme Court said when there is evidence of multiple thefts that the prosecution wants to put before the jury, they have to charge under subsection 4. The legislator stepped in and said, no, they don't. Sometimes there's a weak theft and a strong theft, and the prosecution wants to present both under subsection 1A. Let the jury decide which one it is. That's what happened here, essentially. Even if that was a mistake, essential elements were missing in this case that were not alleged in the charging document and not instructed to the jury, and the jury didn't find. So, yes, it is true that Mr. Hookfin's defense at trial was an intent defense, that he had been operating under a mistake of law. Had the prosecution charged aggregation under 4B, he would have also had the option to fight against the scheme and course of conduct. And that, because that was not charged in this case and instructed or anything like that, he didn't do that. And so it's easy to say, well, it was undisputed what the amounts were, but there would have been a totally different defense available to him had they charged under the different offense of subsection 4B. And finally, with respect to Lewis, in Lewis, and going back all the way to the origins of this crime under subsection 4, Lewis said way back in the 80s that when the prosecution charges under subsection 4, the jury has to make these specific findings. And in Lewis, the jury was unanimous as to 2 of the thefts, and therefore there was no unanimity problem. And I think that that's relevant because Ramos is not out by itself just deciding this case. Ramos relied on these cases and this idea emerging from this legislative history that yes, these are separate crimes. I don't need this court to agree with Ramos about that in order for the error to still exist in this case in any event. But it is a good decision and it was right, and this court should treat these as separate offenses. And the prosecution decided deliberately to go with a single offense, and the prosecution did not prove that offense as alleged in this case. There was just insufficient evidence.
So counsel, is it your view that that case, Lewis, way back from the 80s, is consistent with Ramos?
Yes, yes. I think they're different issues. I think Ramos is merely continuing on with what was already going on in Lewis with that issue, like with what the jury needs to find and these separate elements in subsection 4. And to that extent, it is relevant. So for all the reasons in the opening brief and here today, I would like this court to